All right, we are continuing the Code of Professional Responsibility. Again in Black's Law Dictionary, revised 4th edition, on page XLVI, starting at ethical consideration 5-11. A lawyer should not permit his personal interest to influence his advice relative to a suggestion by the client that additional counsel be employed. Footnote 15 just says ABA Canon 7. End of footnote. In like manner, his personal interest should not deter him from suggesting that additional counsel be employed. On the contrary, he should be alert to the desirability of recommending additional counsel when, in his judgment, the proper representation of his client requires it. However, a lawyer should advise his client not to employ additional counsel suggested by the client if the lawyer believes that such employment would be a disservice to the client, and he should disclose the reasons for his belief. Ethical consideration 5-12. Inability of co-counsel to agree on a matter vital to the representation of their client requires that their disagreement be submitted by them jointly to their client for his resolution, and the decision of the client shall control the action to be taken. Footnote 16 says see American Bar Association Canon 7. Ethical consideration 5-13. A lawyer should not maintain membership in or be influenced by any organization of employees that undertakes to prescribe, direct, or suggest when or how he should fulfill his professional obligations to a person or organization that employs him as a lawyer, although it is not necessarily improper for a lawyer employed by a corporation or similar entity to be a member of an organization of employees. He should be vigilant to safeguard his fidelity as a lawyer to his employer, free from outside influences. All right, we're going to be moving on to ethical consideration 5-14, but it does have a subheading on top of it that reads interest of multiple clients. All right. Maintaining the independence of professional judgment required of a lawyer precludes his acceptance or continuation of employment that will adversely affect his judgment on behalf of or dilute his loyalty to a client. Footnote 17. See ABA Canon 6. See ABA Opinions 261. End footnote. This problem arises whenever a lawyer is asked to represent two or more clients who may have differing interests, whether such interests be conflicting, inconsistent, diverse, or otherwise discordant. Footnote 18. The ABA canon speak of conflicting interest rather than differing interest, but make no attempts to define such other than the statement in Canon 6. Within the meaning of this canon, a lawyer represents conflicting interests when, in behalf of one client, it is his duty to contend for that which the duty to another client requires him to oppose. End of footnote 18. Ethical consideration 5-15. If a lawyer is requested to undertake or to continue representation of multiple clients having potentially differing interests, he must weigh carefully the possibility that his judgment may be impaired or his loyalty divided if he accepts or continues the employment. He should resolve all doubts against the propriety of the representation. A lawyer should never represent in litigation multiple clients with differing interests. We're going to be looking at footnote 19. Canon 6 of the Canons of Professional Ethics, adopted by the American Bar Association on September 30th, 1937, and by the Pennsylvania Bar Association on January 7th, 1938 provides in part that it is unprofessional to represent conflicting interests except by express consent of all concerned, given after full disclosure of the facts. Within the meaning of this canon, a lawyer represents conflicting interests when, in behalf of one client, it is his duty to contend for that which duty to another client requires him to oppose. The full disclosure required by this canon contemplates that the possibly adverse effect of the conflicts be fully explained by the attorney to the client to be affected and by him thoroughly understood. The foregoing canon applies to cases where the circumstances are such that possibly conflicting interests may permissibly be represented by the same attorney, but manifestly there are instances where the conflicts of interest are so critically adverse as to admit one attorney's representing both sides. Such is the situation which this record presents. No one could consciously I'm really having trouble pronouncing this word. It's like unconscionably, like an unconscionable contract, but it's consciously. Okay, I think I got it. No one could consciously contend that the same attorney may represent both the plaintiff and defendant in an adversary action. Yet, that is what is being done in this case. Jed Wamby versus Philadelphia Transportation Company. Alrighty, that was the end of footnote 19. And there are few situations in which he would be justified in representing in litigation multiple clients with potentially differing interests. If a lawyer accepted such employment and the interests did become actually differing, he will have to withdraw from employment with likelihood of resulting hardship on the clients. And for this reason, it is preferable that he refuse the employment initially. On the other hand, there are many instances in which a lawyer may properly serve multiple clients having potentially differing interests in matters not involving litigation. If the interests vary only slightly, it is generally likely that the lawyer will not be subjected to an adverse influence and that he can retain his independent judgment on behalf of each client. And if interests become differing, withdrawal is less likely to have a disruptive effect upon the causes of his clients. Ethical consideration 5-16. In those instances in which a lawyer is justified in representing two or more clients having differing interests, it is nevertheless essential that each client be given the opportunity to evaluate his need for representation free of any potential conflict and to obtain other counsel if he so desires. Footnote 20. Glasser wished the benefit of the undivided assistance of counsel of his own choice. We're going to read that again. It says Glasser wished the benefit of the undivided assistance of counsel of his own choice. We think that such a desire on the part of an accused should be respected, irrespective of any conflict of interest. The additional burden of representing another party may conceivably impair counsel's effectiveness. To determine the precise degree of prejudice sustained by Glasser as a result of the court's appointment of Stewart as counsel for Christie is at once difficult and unnecessary. The right to have the assistance of counsel is too fundamental and absolute to allow courts to indulge in nice calculations as to the amount of prejudice arising from its denial. Glasser versus United States. End of footnote 20. Thus, before a lawyer may represent multiple clients, he should explain fully to each client the implications of the common representation and should accept or continue employment only if the clients consent. Footnote 21. See ABA Canon 6 in the footnote 21. If there are present other circumstances that might cause any of the multiple clients to question the undivided loyalty of the lawyer, he should also advise all of the clients of those circumstances. Footnote 22 just says ID in italics. End of footnote 22. Ethical consideration 5-17. Typically recurring situations involving potentially differing interests are those in which a lawyer is asked to represent co-defendants in a criminal case, co-plaintiffs in a personal injury case, and insured and his insured. Footnote 23, ABA Canon, Opinion 282-1950. When counsel, although paid by the casualty company, undertakes to represent the policyholder and files his notice of appearance, he owes to his client the assured and undeviating and single allegiance. His fealty embraces the requirement to produce in court all witnesses, fact and expert, who are available and necessary for the proper protection of the rights of his client. The canons of professional ethics make it pellucid that there are not two standards, one applying to counsel privately retained by a client and the other to counsel paid by an insurance carrier. American Employers Insurance Company versus Globe Aircraft Specialties. Counsel selected by State Farm to defend Dorothy Walker's suit for $50,000 damages was apprised by Walker that his earlier version of the accident was untrue and that actually the accident occurred because he lost control of his car passing a Cadillac just ahead. At that point, Walker's counsel should have refused to participate further in view of the conflict of interest between Walker and State Farm. Instead, he participated in the ensuing deposition of the Walkers, even took an ex parte sworn statement from Mr. Walker in order to advise State Farm what action it should take, and later used the statement against Walker in the district court. This action appears to contravene an Indiana attorney's duty at every peril to himself to preserve the secrets of his client. That was from State Farm Mutual Auto Insurance Company versus Walker out of 1967, and that will be the end of footnote 23. And beneficiaries of the estate of a decedent. Whether the lawyer can fairly and adequately protect the interests of multiple clients in these and similar situations depends upon an analysis of each case. In certain circumstances, there may exist little chance of the judgment of the lawyer being adversely affected by the slight possibility that the interests will become actually differing. In other circumstances, the chance of adverse effect upon his judgment is not unlikely. Ethical consideration 5-18. A lawyer employed or retained by a corporation or similar entity owes his allegiance to the entity and not to a stockholder, director, officer, employee, representative, or other person connected with the entity. In advising the entity, a lawyer should keep paramount its interest, and his professional judgment should not be influenced by the personal desires of any person or organization. Occasionally, a lawyer for an entity is requested by a stockholder, director, officer, employee, representative, or other person connected with the entity to represent him in an individual capacity. In such case, the lawyer may serve the individual only if the lawyer is convinced that differing interests are not present. Ethical consideration 5-19. A lawyer must represent several clients whose interests are not actually or potentially differing. Nevertheless, he should explain any circumstance that might cause a client to question his undivided loyalty. Footnote 24, read see ABA Canon 6. End of footnote 24. Regardless of the belief of a lawyer that he may properly represent multiple clients, he must defer to a client who holds the contrary belief and withdraw from representation of that client. Ethical consideration 5-20. A lawyer is often asked to serve as an impartial arbitrator or mediator in matters which involve present or former clients. He may serve in either capacity if he first discloses such present or former relationships. After a lawyer has undertaken to act as an impartial arbitrator or mediator, he should not thereafter represent in the dispute of any of the parties involved. We're going to be stopping there at ethical consideration 5-20. I really appreciate your time listening to this recording. Again, as always, this is not legal advice. I do not offer legal advice. If you do want some form of legal advice, please obtain competent counsel and get your advice. This is only for informational purposes, protected by free speech of the First Amendment provided for in the Constitution for the United States of America. Again, if you do need to reach me for whatever reason, there should be contact